Hi, my name's Isaac Shutt. I'm an estate planning attorney. I'm licensed both in Texas and in Wyoming. Today I'm going to talk about a question that I hear all the time, and that is, who gets it all when I die? And really that boils down to just 4 factors. Number 1 is, do you have beneficiary designations on your accounts? Number 2 is, do you have a will or a trust? Number 3 is, well, what do you own? And number 4 is, what family do you have? So let's take those in order. Number 1, well, if you have beneficiary designations, that's almost always going to trump. That's really important because if you had beneficiary designations on your checking account or your savings account or your retirement account, but you also have a will, let's say those beneficiary designations on your will or your trust don't match what's on your checking account or savings account and the beneficiaries you had designated on those. Well, guess what? The beneficiary designation that you have on file with the financial institution like the bank with your checking or savings or retirement account, the designated beneficiaries will trump whatever your will or trust says. So it doesn't matter if you had one account and in the beneficiary designation on file with the bank says that your daughter Sally inherits everything, but your will says that same account would instead go to your son Billy. Guess what? Sally wins. Sally's going to get that account because the beneficiary designation on that account will trump. So the first factor is, do you have beneficiary designations, and those beneficiaries on that account will win. And by the way, if you designated Sally and you were just sort of trusting that she would split it up in accordance with your will, that's a terrible idea. Don't do that, but I've got other videos that talk about that. So the moral of that story is the beneficiary designation is going to trump. That person that you put on there is going to get it when you die, so be very careful when you do that. Number 2 is, do you have a will or a trust? So a lot of our clients actually pass away with neither, or maybe not a valid one. Maybe they've had us help set up an LLC or something else, but they never got around to actually doing a will or a trust. Well, first and foremost, you should totally have a will or a trust. If you don't have one, it's so easy. And especially now with a good dedicated estate planning attorney, there's really no good reason not to have one. But aside from that, if you have a will or a trust, then if there's no beneficiary designation, basically your will or your trust is going to control. So if you've got one of those, terrific. As long as the will is valid, and most of the wills done by lawyers are going to be valid, you're probably covered, and those beneficiaries designated in your will or your trust are going to win. So really the meat and potatoes of why I'm sure you're watching this video is really who gets it if I die and I don't have beneficiaries designated and I don't have a will and I don't have a trust. Who gets it all then? Well, then you get into factors number 3 and 4. Factor number 3 is, well, what did you own? And factor number 4 is, well, what family do you have? And so that's really going to dictate who gets what. At least in Texas, we are a community property state. So when we talk about what assets you own, those assets are going to be characterized as either community property or separate property. And then within that, you're going to have personal property and real property. So really, altogether, there are 4 classes of property when a person passes away. And everything you own is going to be classified in one of those classes. So it's either going to be, for a married person, community property that's real estate, community property that's not real estate, separate property that's real estate, and separate property that's not real estate. So those are the 4 classes of property for married people. There's only 2 classes if the person dies and they weren't married. You would just have real property and personal property. So under the Texas Estates Code, who gets what really depends on the classification of property. So there's a really kind of a complicated code that talks about who gets what in each one of those, and we call that intestate succession. And it gets even more complicated than that, and it kind of relates to factor number 4, what family do you have? Because sometimes a person passes away with children, sometimes without children, and then even beyond that, it matters whether or not those children were born during the marriage that the person had when they passed away, or born to a previous relationship to the person who they were married to when they passed away. So all of this matters. Now, typically we see, just most commonly, we see people who pass away who are married with children. So let's just talk about that for a moment. Okay, let's say you have property and you pass away and you're married and you have kids from that marriage. Well, in that case, all of the community property is going to go to the spouse. Now, it's not automatic. There'll be a probate process, but all the community property, whether that's community real estate or community separate property, will go to the surviving spouse. The separate property gets split up a little bit differently, but most of that goes to the spouse as well. Where things really get bizarre, as a lot of our clients would say, is when a person dies who's married but has at least one child from a previous relationship. Well, then each one of those 4 classes of property gets really interesting, because the spouse who comes into our office, like let's say it's a widow, she comes in assuming that she inherits everything. Well, guess what? Not only does she not inherit everything, she may not be getting any of the community property at all. See, under the Texas Estates Code, if you die married with at least one child from a previous relationship, all of the deceased spouse's share of community property, and that's all property that was acquired during the marriage, or most of the property acquired during the marriage, is actually going to the children of the deceased spouse. It doesn't even go to the surviving spouse. So that is really shocking to a lot of our clients, because we have, a widow maybe who comes in and says, I've lost my spouse and I think I inherit everything. And then we learn that the deceased person had at least one child from a previous relationship. And we have to say, no, I'm sorry, ma'am. Not only do you not inherit everything automatically from your deceased husband, actually all of his community real estate, which is your homestead, and all of his community personal property, which is like the money in his bank accounts and all of that kind of stuff, actually his share of the community half goes to his kids, not to you. So not only is it not automatic, it may not be going to you at all. I'm sorry, surviving spouse. And then if in that same scenario where the person has died married but with at least one child from outside the marriage, the separate property is even more complicated. So if there's separate real property, so this would be like if the deceased spouse had property that he acquired from before his marriage to the surviving spouse, or if he had property that was gifted to him either by inheritance or by gift, then that separate real property goes all to the to the children or the descendants. But the surviving spouse has what's called a 1/3 life estate. So that means the surviving spouse would get 1/3 of, for example, rental income on that separate property. And then when she passes away, that 1/3 life estate passes away as well. And the kids can kind of do whatever they want with the property after that. And then if the deceased spouse had separate personal property, so this would be like money in the bank that he got from before the marriage, or that he got from gift or inheritance or things like that, that goes 1/3 to his surviving spouse and 2/3 to his children. So this is really a shocker to people who are like surviving spouses when the deceased spouse had at least one child from outside the marriage, because they think they're getting everything. And boy, it's really complicated. And a lot of times what ends up happening in those situations is that the surviving spouse will end up orchestrating sort of a buyout with the deceased person's kids, because they really don't want to be joint property owners. The surviving widow and the kids from the deceased person, it's just not real fun to be a co-owner with your stepmom. So a lot of times they'll orchestrate a buyout so that they can just kind of move their separate ways. And that's a really good option. But really, if there's one moral to this story, it's that it's complicated. This question of who gets it all if you die without a will, it's complicated. And really, that only is complicated if you don't use beneficiary designations and you don't have a will or trust. It's only complicated if you don't do those things. If you have beneficiary designations and you have a good, valid will or a trust, then it goes to the people that you've designated, and it becomes much, much, much simpler. I hope you found this video helpful, and if I can answer any other questions for you, I'd love to hear from you. Again, my name's Isaac Shutt, and I'm a estate planning attorney licensed both in Texas and in Wyoming.